along in the office. There were a couple of errors on our, for Senate Bill 175 in our agenda. So we're getting those corrected here real quickly. We're going to start with Senate Bill 126, and we'll begin with the reviser's memorandum from Jenna.
Good morning, committee. Happy Monday. Senate Bill 126 enacts the Physician Assistant Licensure Compact to provide interstate practice privileges for physician assistants. Section 1 states the purpose of this compact, which is to enhance the portability of a license to practice as a physician assistant while safeguarding the safety of patients. Section 2 provides definitions for terms used throughout the compact. One of those is defining PA and physician's assistant interchangeably, so they mean the same thing. Section 3 sets out the criteria for states to participate in the compact. These include that the member state licensed physician's assistants, that they have a mechanism in place to receive and investigate complaints, that they fully implement criminal background check requirements, and utilize passage of a recognized national licensure examination as a requirement for PA licensure. Section 4 is on page 4, and it sets out the criteria for PAs to receive a multi-state license. These include graduating from an accredited physician assistant program, holding current certifications, having no felony or misdemeanor convictions, and no revocation of a license or restriction on that license due to adverse action. Section 5 is on page 5, and it requires a licensee, when applying for a compact privilege, to identify the participating state from which the licensee is applying. Section 6 is adverse actions, and it permits a participating state to impose adverse action against a licensee in that state. Section 7 provides for the establishment and operation of the PA Licensure Compact Commission, its composition, powers, and financing. Excuse me, that's several pages. Section 8 begins on page 13, and it requires the commission to develop and use a coordinated data system and reporting system containing license and adverse action information. On licensed PAs, a participating state is required to submit a uniform data set to the commission with the information on all PAs in the compact. Section 9 begins on page 14, and it requires the commission to adopt rules and regulations to implement and administer the provisions of this act, and sets out how the commission would do so. Section 10 on page 17 sets out the rules for oversight, dispute resolution, and enforcement of the compact. Section 11 states that the effective date of the compact is upon passage in the 7th member state. It also sets out procedures for a state's withdrawal of the compact, and you get into a compact the same way that you get out of a compact the same way you get in, which is passing a law. And section 12 is construction and severability, and it has a severability clause, which this committee should be fairly familiar with by now. And section 13 provides that nothing in the compact will prohibit or inhibit the enforcement of any law or regulation in a participating state. Senate Bill 26 would take effect after its publication in the statute book, which is July 1st, 2025. And I'll be happy to answer questions.
Thank you, committee. Any questions for Jen over this bill? You all have it memorized? Yes.
Yeah.
Senator Thompson.
Yeah, I just did real fast. Of course, I love creating new compact commissions. There's no other commission that could absorb this kind of duty, or we have to have a specific commission for this?
That might be a question for the proponents.
Yeah,
Okay.
probably more of a
All right. Thank you, Madam Chair. Thank you, Jenna.
So we are going to begin with our oral proponents. Keith Marshall, are you in the room? Welcome, Lieutenant Colonel.
Good morning, Madam Chair, members of the committee. Lieutenant Colonel Keith Marshall with the Kansas Adjutant General's Department and the Kansas National Guard. So in 2023, Congress passed and the President signed into law the Military Spouse Licensing Relief Act. And what that intended to do is provide licensure portability for military spouses across all 50 states. So as often as military families have to move, allow the military spouses to get back to work after a move. So these compacts are overseen by the National Center for Interstate Compacts, and there are 17 of these that are available for states to enact at this point in time. And to my understanding, Senator, for your question, it does require them to be enacted one by one, unfortunately. So Kansas has already passed 9 of these compacts, and there are 5 more being considered this legislative session. So the Kansas National Guard stands in support of these for military spouses and military families. We don't move as frequently as our active duty counterparts typically, but we do move on occasion, and we also recruit pretty heavily from active duty and from other National Guard states. So we do have families and service members that move from out of state to Kansas, and we would like to see this enacted for licensure portability for those families when they do move to Kansas with their service member. So just in summary, we stand in support of the bill for National Guard families, but also for all military families in the state of Kansas. And with that, Madam Chair, I will stand for questions at the appropriate time.
Thank you. We'll save the questions till the end of the proponents, and now we go to Michelle Rickard. I believe she's virtual, or were we able to get her? She's there. Okay, Michelle, can you hear us?
I can. Can you hear me?
Yes, please go ahead. You'll have about 2 minutes.
Thank you. Chairman Gossage and honorable committee members, my name is Michelle Richard. I'm the Midwest Region Liaison for the United States Department of Defense, specifically the Defense State Liaison Office. We operate under the direction of the Undersecretary of Defense for Personnel and Readiness and the Deputy Assistant Secretary for Military, Community, and Family Policy. On behalf of military families and the DoD, we support the policy changes expressed in Senate Bill 126 related to the Physician Assistant Licensure Compact. This bill addresses licensing issues that affect our service members and their families. Licensure issues for both our transitioning military members and the spouses have been a priority for the department for several years. Occupational licensure compacts provide consistent rules that allow licensed members to work in other states through privilege to practice policies or to transfer their license more easily to a new state. The military provisions added to these compacts assist military members and their spouses to participate in these occupational compacts. As our military members and their families move from state to state, obtaining licenses to obtain employment is very important. Military spouses have a 21% unemployment rate, a rate that is much higher than the national average. Compacts such as this one will serve to relieve one of the many stressors of a military move and support our military families' financial readiness and personal well-being, and help the readiness and resiliency of our armed forces. We are grateful for the tremendous effort that Kansas has historically made to support our military members and their families, and appreciate the opportunity to support this Physician Assistant Licensure Compact. Thank you for considering this issue during the 2025 session, and I stand by for any questions that you may have. Thank you.
Thank you very much. Next, we will have Doug Smith. Doug, are you in the room? Sorry, Doug, I didn't see you. Welcome to committee.
Sorry. Doug Smith here on behalf of the Kansas Academy of Physician Associates to testify in support of Senate Bill 126. I'd first like to start out and just update you on a name change. Kansas Academy of Physician Associates changed their name from assistants this year. It's part of a national effort by our American Academy of Physician Associates. They've rebranded, and so we're going to start using the term associates in our profession. But right now, physician associates will only use PA or physician assistant until there's some statutory enactment. So if you get confused, just call us PAs, and we're fine with that. So on Senate Bill 126, this concept started with the National Academy of Physician Associates, the Federation of Medical State Boards, the NCCPA, which is the National Commission on Certification of Physician Assistants, and the Council of State Governments. They're the ones who brought this project together, and we are here to support those efforts. We believe that this will streamline the process for attracting highly qualified healthcare professionals. We believe it'll benefit patients by increasing access to care and improve the continuity of care, and ultimately increasing the availability of skilled providers. It will also provide a multi-state data system that will enhance the public protection by facilitating the sharing of licensure and disciplinary information across compact states. And will also increase the portability of the licensed for physician associates or assistants in particular states. The revisor noted that in order to qualify for this privilege, the PA must hold an unrestricted license in a member state, meet the essential state licensing requirements, which may include background checks, and have a valid certification for the NCCPA. We want to emphasize that the compact does not alter or extend the scope of practice for PAs in Kansas, and the compact preserves the existing state control over the scope of practice, collaboration, and supervision requirements, prescribing authority, and the initial licensure. Passing this compact will allow Kansas to join the other states surrounding, and in our testimony, you can see a map that we have a number of states on our border that have already adopted this compact, and it will facilitate a greater workforce mobility. I understand that there will be two corrections or technical amendments that need to be made to the bill, and we would support those. And I would ask you to pass Senate Bill 126 favorably and stand for questions when you're.
Thank you, Doug. I let you go a little longer because I knew that you wanted to get to those, and also because some of your fellow proponents didn't take their full 2 minutes. Committee, are there questions for the proponents? There are no opponents. Senator Petty.
Good morning.
Forgive me, William. I see you at the back of the room. And then we'll have Senator Petty. Go ahead, William, and you have your 2 minutes.
Thank you. Good morning, Madam Chair, members of the committee. My name is William Wilkes, Senior Director of Government Affairs for the Kansas Chamber of Commerce, and we appreciate the opportunity to provide the committee with proponent testimony to Senate Bill 126 today. The Kansas Chamber formed the Military and Veteran Affairs Council in 2023, and the mission of the Military and Veteran Affairs Council is to provide a unified voice to support and grow our state's military institutions and to build a stronger relationships between the service members and employer communities. One legislative issue that was brought to our council's attention last year was the occupational licensing compact issues. As you have heard, these compacts are Department of Defense initiatives, and they just help streamline the process for licensing recognition for military spouses across state lines. Now, it is important that the language remain the same with all these compacts that are passed in states, so you will see in my testimony that I do have a couple technical amendments, and these amendments were offered by CSG, who drafts the compacts. First, in Section 3A5, deleting the word examination and replacing it with by its licensing board receiving. So that section should read, fully implement a criminal background check requirement within a time frame established by a commission rule by its licensing board receiving the results of a criminal background check and reporting to the commission whether the applicant for licensure has been granted a license. And then secondly, in Section 7, page 10, line 31, just simply deleting the word contract and replacing it with compact. In closing, the Kansas Chamber views that these compacts are a necessary step to increase access to physician associates for Kansans and fast-track the licensing process for military spouses moving into our state. And with that, I'm happy to answer any questions you might have at the appropriate time.
Thank you, William. And now we'll open it up for questions from Senator Petty.
Thank you, Madam Chair, and this goes back to Doug. So I certainly appreciate your educating us on going from assistant to associate, because I was looking at your testimony, I was like, oh, new name. Could you just refresh for me, so PAs, we have programs in Kansas, and their background, their educational background, what it takes to become a PA. Could you refresh that for me?
Yes, we have two training programs here in Kansas, Wichita State and Kansas State University, for an applicant, they need to have a bachelor's degree, and typically it's in some kind of one of the sciences or a pre-med. And generally, they also have some form of medical education, either through service as a EMS or medical assistant, and then they apply to the program. It's a 27-month program here. They have over 2,000 clinical hours in addition to their school time in their training, and then have to pass this national examination for licensure.
Thank you. And so, and then the second thing is that I know the compact takes 7 states, and it appears from the map that you included in your testimony that there already are over 7 states that are in the compact.
That's correct. There are 13 states and I think 10 others considering it. That triggered the creation of the commission to start making their rules for the compact, and that started in September. So we're really on the early portion of the development of the compact.
Thank you.
Senator Thompson, did you have a question?
I do, Madam Chair. Thank you very much. Question on, it looks like Missouri doesn't have a compact. Do you have any indication that they have, at least on your map, any pending thoughts on legislation? Also, some big military states like Florida, California, don't have compacts, and I know that might impact the military folks.
In our initial discussions with Missouri, it's on their list. It's just not their top priority right now. I think they have some other changes that they would like to make for their profession and just haven't introduced anything in Missouri at this point. As far as the other military states, I haven't really heard anything at this point, but I'm sure they're considering it.
Okay, thank you. Thank you, Madam Chair.
Doug, when we visited my office, we talked about, my concern has always been when it comes to compacts is the tail wagging the dog. And it sounds benign initially, we're going to join a compact and it's going to make us easier to be able to practice in particularly adjoining states or like the military moving from state to state. We're all for that. But what becomes an issue is the compact will say, we as a group believe this, so go back to your state and convince them to implement X, Y, Z. And can you share with our members what you shared with me about that?
Well, I think it's important with the development of this compact commission to be one of the early participants, because every state who participates gets a seat at the table in the development of any rules and regulations that they may have. So I think if Kansas can be an adopter, we're at the negotiating table as the commission works. And I think you see some of the states that might have concerns are people who adopt late, and maybe they have some conditions in their state law that just don't qualify. But in our discussion, real briefly with the Board of Healing Arts, they didn't indicate there were any requirements right now that they don't comply with. So I think as long as we are a participant in the setup of the compact, we shouldn't have any concerns. And obviously, if a state can't meet those concerns, they can drop out of the compact.
Thank you, committee. Other questions? Seeing none, this closes the hearing on Senate Bill 126, and we will open the hearing on Senate Bill 175. Jenna, would you give us a brief?
Thank you, Madam Chair, members of the committee. Senate Bill 175 relates to athletic training. Section 1 updates the definition of athletic training in KSA 65-6902 from a fairly simple definition of just the practice of preventing injury and physical evaluation, emergency care, to the practice of prevention and wellness promotion, risk management, immediate or emergency care, examination, assessment, and therapeutic intervention, or rehabilitation of injury and illness. And it goes on a little further, but that's the gist. Section 2 amends KSA 65-6906, and it applies to a person licensed in another state or jurisdiction who is accompanying an athletic team or organization from another state and providing athletic trainer services. And it allows that licensee from another state to be exempt from the licensure requirements of that act if that person limits their athletic trainer services to the members of that athletic team. You may remember the legislature passed Senate Bill 131, I believe it was 2 years ago, and it applied to physicians accompanying athletic teams to allow the physician to be exempt from licensure in this state if they were being a physician for an athletic team. This does that same thing, but just for athletic trainers. Section 3 amends KSA 656907, and it clarifies some language for an applicant for licensure as an athletic trainer shall provide proof of successful completion of the curriculum requirements of an accredited athletic training education program at an accredited college or university, just updating that degree proof language. And that covers it for this bill. I'll be happy to answer questions.
Excellent, Jenna. Thank you so much. I know you've been overwhelmed with so much, and we really appreciate you. We are going to first ask if there are any questions for Jenna before we move to our oral proponents. Any questions for Jenna? Senator Thompson.
Thank you, Madam Chair. And maybe this is for one of the proponents too, but Jenna, I was just looking at the definition that changes there on what athletic training means, and talking about immediate emergency care, examination, assessment, therapeutic intervention. Is this going to create any potential liability or requirement for malpractice insurance? I don't know. I'm just kind of curious.
That's probably a good question for the proponents of this bill, as it relates a little bit more to exactly what's within the scope of practice for those individuals.
Okay. Thank you, Madam Chair. Thank you, Jenna.
Absolutely. Thank you, Jenna. Committee, as you've seen, again, we are shorthanded in our office, and so we had the opponents before the proponents, but we are going to begin with the oral proponents. Shauna Jordan, welcome.
Thank you, Madam Chair and Committee. I'm Shauna Jordan, and I represent the Kansas Athletic Training Society, which is the purpose of our society is to advance the profession of athletic trainers in the state, which is more than 550. Athletic trainers are healthcare professionals that collaborate with physicians to optimize activity and participation of patients and clients. The purpose of our Practice Act update is to modernize the statute and rules and regulations to reflect the current athletic training educational requirements and ensure that athletic trainers are able to work to the fullest extent of their education and skill set. Amending the definition of athletic training really expands what our roles and responsibilities of athletic trainers based on the educational requirements. Our profession has changed from a bachelor's only to now requiring a master's degree from an athletic training accredited education program in order to set for the national examination. We also are asking for the incorporating a reciprocity clause, and we look forward to working with the Board of Healing Arts to take lead as we work to really look at the rules and regulations process, as we know there'll need to be definitions for some of these areas. An example of the organizations would be, we have CIRC, that is a performing arts company that has come to Topeka that actually employs athletic trainers. We also have Justin Sports Medicine Rodeo, that is another example of an organization that comes into the state where athletic trainers work with Justin Sports Medicine. The athletic training education requirements are in line with our Commission on Accreditation of Athletic Training Education for compliance and accreditation standards. We currently have 5 graduate-level accredited athletic training education programs within the state. This update will allow the graduates of those programs to be able to stay in the state and practice, where many now may be leaving. We also have an economic impact for the state of Kansas. Currently, Fort Leavenworth is looking to hire 46 certified athletic trainers to lead their Army Holistic Health and Fitness program. This update to our Practice Act will allow those individuals to look for opportunities in this setting. Athletic trainers are employed not only in an industrial setting, emergency response teams, traditional secondary schools, hospitals, clinics, collegiate, and performing arts. And to address Senator Thompson's question, we actually all have to carry malpractice insurance to be able to practice in this state. Our leadership team has been working closely with the AT Council and the Kansas Board of Healing Arts to work through this, and the Board of Healing Arts has provided great leadership as we work to update the statutes and then the next step of updating the rules and regulations. Thank you.
Thank you. And next we have Kimberly Martin. Oh, I'm sorry. Okay, she is written only. We had someone else in the room, but I'm afraid we did not receive written testimony. So we're going to go ahead and open this up for questions for the Proponents Committee. Yes.
Thank you, Madam Chair. What's the limit on the malpractice insurance? Do you happen to know? I didn't see it in your written testimony.
I did not put it in the written. I actually couldn't tell you off the top of my head.
Just get back to me. Why are they leaving the state once trained or once certified?
Currently is some of the limitations that of where they're able to be at. It is hopeful that as we start to expand with the industrial settings that are being provided, and also now with the military expansion of hiring the athletic trainers, many want to stay in the state, but many are leaving to go work clinics and hospitals outside of the state.
Thank you. Thank you, Madam Chair.
Senator Petty.
Thank you. And Shauna, I had some athletic trainers visit me earlier this session. And are all the programs now, are they master programs?
Yes, you're correct, Senator. Everything has to be a master's level now to be able to set for the national exam. So all the individuals that came to see you, yep, were some of our graduate students.
Thank you.
Yes, Senator Holscher.
Thank you, Madam Chair. Thank you for being here. I guess my question pertains more to the high school or collegiate level. If you have a team that's traveling and there's an injury, my understanding is currently then there's a delay potentially in care.
There could be, especially for our smaller institutions, the Big 12 institutions travel their athletic trainer and physician with them, but some of our NAIA or our community colleges may not always be able to travel that athletic trainer, or vice versa. Those schools may be sending, let's say, for instance, a small school from Missouri comes over, they may not have their athletic trainer with them right as we speak right now, where the reciprocity would allow them to travel and have that opportunity to be with their team.
Additional questions, committee? All right, seeing none, we are ready to move to opponent testimony. Jennifer Caswell.
Thank you, Madam Chairwoman Gossage and committee. My name is Jennifer Caswell. I'm a physical therapist, and I am here as the legislative chair for American Physical Therapy Association, Kansas chapter. We do oppose Senate Bill 175, primarily due to public safety. This bill specifically removes the crucial phase relating to athletic activity from the athletic trainer's scope. This single change dramatically expands their practice beyond tested competencies. Patient safety could be compromised by allowing practice beyond the formal training. We also have an issue with timeline. We've worked with athletic trainers over the years, and we want to continue to work with them. But we just found out about this bill last Tuesday, found out on Wednesday that they had a hearing scheduled, and then Wednesday afternoon, one of their past presidents from the Kansas Athletic Training Society alerted us to this bill, letting us know that there was just a modernization of their Practice Act. Once we looked at it, we did have concerns again that they struck those words relating to athletic activity from their bill. We feel like this rushed process doesn't allow us the time to speak with them. We were able to speak briefly with them Friday afternoon, but still weren't able to get all of our questions answered, so that was some concerns we have. Then when we look at the certification under the rules and regs, although I know Shauna did mention it, we're a little bit concerned about the current certification requirements that are listed. The national exam only tests athletic injury competencies. So there are 6 domains that are listed, all specifically relating to athletic injuries, in quotes. There's no testing on general population or the non-athletic injuries. And training and assessment doesn't match the proposed scope expansion, and that is one of our big concerns. We do have some constructive solutions that we'd like to hear. So we're not here just to oppose, but we want to work together with the athletic trainers. We would suggest that they pause the current legislation, conduct proper stakeholder review just to make sure safety again for the public, include all healthcare professionals and patient advocates in this discussion, and develop safe and appropriate practice standards, and perhaps look at supervision protocols that could be helpful in this vein. And APTA Kansas does stand ready to collaborate with them. So in conclusion, this isn't about protecting territory, it's about protecting patients and clients. We ask the committee to prioritize patient safety over rush legislation. Thank you again for your time.
Committee, any questions for Jennifer? Yes, Senator Clifford.
Thank you, Madam Chair. Thank you for your testimony. I feel like this needs to occur, but absent that phrase that you cite related to athletic activity, if that went back in on page 14, would you be okay with the other provisions of this?
Likely we would be neutral with the bill, yes.
Thank you. Thank you, Madam Chair.
Additional questions for the opponent? Seeing none, we have neutral opponent or a neutral oral. It's not an opponent at all. Neutral, Travis Aller. Thank you for being here.
Thank you, Madam Chair and members of this committee. Thank you for the opportunity to testify on SB 175. Dr. Travis Aller, Executive Director of the Kansas Chiropractic Association, and we're offering neutral testimony and can support this bill with amendments. Athletic trainers typically work under a practice protocol, also known as standing orders. This practice protocol is an agreement between the athletic trainer and either a medical physician or a doctor of chiropractic that outlines when an athletic trainer can evaluate and treat a patient, as well as which treatment modalities an athletic trainer can use. We support the efforts of the Kansas Athletic Trainer Society to update the language of their Practice Act to more align with the modern definition of athletic training. Our concern is with Section 2F, the reciprocity. Section 2F is blanket reciprocity with no restrictions for athletic trainers licensed in other states. As written, Section 2F does not offer a definition of athletic team or organization, nor does it require an athletic trainer to operate under a practice protocol or have malpractice insurance. It just requires them to be licensed and able to treat in another state. Travel to treat was addressed by this body in 2023 with the Kansas Sports Waiver Medicine Waiver Act, SB 133, or 131, sorry. I talk fast and get ahead of myself. This set up a system that actually allowed all provider types licensed by the Kansas Board of Healing Arts to apply for a sports waiver to travel to treat with an athletic team. We feel that SB 131, if it does require some modifications, is a better reciprocity agreement than what is in Section 2F. SB 131 requires all provider types that are licensed by the Board of Healing Arts to notify the Board of Healing Arts that they are practicing in Kansas with an athletic team. We asked this committee amend SB 175 to remove the language of Section 2F in order to protect patients. In the alternative, we asked the committee to define athletic team or organization in this bill. As we all have seen, I'm sure, undefined terms have a habit of running away. Athletic team without a definition could mean Billy Bob's bowling team from Oklahoma. The athletic trainer that's on that team gets to come to Kansas and treat anybody within the organization hosting that tournament. So we would like a definition at the minimum. I will stand for questions at the appropriate time.
Other questions for Dr. Aller? Senator Petty.
Thank you. And thanks for being here. Is there currently in other, like you mentioned Senate Bill 131, is there a definition in that bill for athletic team?
I do not know. I would have to look at that.
That might be a good question for Jenna as well.
I can get back to you.
Thank you, Madam Chair. Senator, I'm looking at that statute right now. It's KSA 6528,136, and I do not see a definition in that statute at the moment.
Thank you.
Are there other questions? Madam Chair, I'll answer to you now. I have a question.
Go ahead, Senator.
So how would a traveling out-of-state physical trainer get an agreement with a Kansas physician? That's what you're indicating with the Kansas State Board of Healing Arts.
Thank you, Madam Chair. Senator Clifford. My understanding is that they're practicing under a practice protocol in another state. And that would be good enough. We just need to know that they're doing that. This bill doesn't require them to have a practice protocol with anybody anywhere. As long as they're licensed and able to treat, they can come into Kansas.
I'm not a lawyer. Follow up, Madam Chair. Thank you. I'm not an attorney, but where would the standing be? I mean, maybe they injure one of their own players or they don't get their care fast enough. Wouldn't the standing be back in their home state? Or, I know you're not a lawyer either, so I'm sorry. Maybe we'll ask the revisor.
Madam Chair, Senator Clifford, I am not an attorney either, but it is my understanding that if in the event of an adverse outcome, that the standing would be in the location where the treatment was rendered.
Okay, thank you. Thank you, Madam Chair.
Committee, any other questions? Seeing none, this concludes the hearing on Senate Bill 175. Committee, at the end of your agenda, I appreciate that it was written in from somebody in the office, but they mistakenly put 8:30 p.m. We will be meeting at 8:30 a.m. in the morning, and we will be have a hearing on Senate Bills 82 and 88. We may take final action if time on some of the bills or one or two of the bills that we've heard already. Thank you very much, and we are adjourned.